Hi, everybody. If you're watching this, you're watching Tyler Law's summaries of the new 2023 California laws for real estate. My name is Bradley Greenman. I'm an associate at Tyler Law.
And my name is Myla Rizal Sarmiento, and I'm also an associate with Tyler Law. So, Brad, I have some questions regarding what's happening in real estate law. The first one is, what's going on with the common interest developments?
There is a new common interest development law or revisions to the existing law that has been made as Assembly Bill 1410. There's a free speech element to this new law, which may not seem too relevant to a lot of practitioners, but if you're a homeowners association or you are on the board of a homeowners association in some capacity, the new law makes it illegal to have any restrictions within your homeowners agreements with all the members of the homeowners association, controlling any type of speech that they have on social media that could be critical of the homeowners association. And so I think during COVID, they ran into issues with homeowners associations trying to punish or penalize members for speaking out on different policies online, and this law makes it illegal for homeowners associations to do that. So if you have anything in your agreements or in your contracts with your members to that effect, it needs to be taken out. It is otherwise void and unenforceable.
Or just kind of be careful what you put on social media, right?
Yeah. And for the members, you don't have to be rude. You can be careful. That's not always the best place to go to be critical. It's not always the most diplomatic place to express things about your homeowners association. I think the other relevant thing, we're always dealing with the pandemic still, even 3 years removed from when it began. But there is a new restrictions placed on homeowners associations during a declared emergency by the governor. You cannot enforce certain provisions that would be unsafe to comply with. Now, that's a really vague and broad category, what would be unsafe to comply with. Yard work. Does this involve like aesthetics, yard works, things like that, or holding meetings inside on a regular basis? Maybe that has to change to Zoom or something like that. And so there's not too many specifics there yet, but there are changes in light of COVID now if it's a declared emergency to be aware of.
Got it. Thank you, Brad. And I know this is a hot topic, but what are some of the things that are changing regarding certain terms with landlord and tenant, or what's going on with that?
Yes, the California Law Revision Commission is doing a study into the use of different terms within real estate contracts and real estate laws. And where this has interesting crossover, this is the new law review. I've also written a new real estate forms review of new real estate forms the California Association of Realtors is using. And they're already preemptively, before the study's even been conducted, changing the terminology that's used in contracts, especially lease agreements or rental agreements between landlords or tenants. California Association of Realtors is actually no longer using the term landlord in any of their lease agreements. They're changing it to housing provider. And so I think in that spirit, the Law Review Commission is going to be researching various terms that contracts use to see if we can find more inclusive, more updated terms, in at least as far as the law is concerned as well.
Oh, wow. So I believe that's going to take some time for everyone to kind of revisit and review their agreements.
Yeah, for sure.
That language.
For sure.
All right. So for all you upcoming real estate brokers, there are some changes that are happening with your exam. Brad, can you tell us a little bit about what's going on?
Yeah, absolutely. It was interesting here. This is the more practical side of some of the new law changes. But the exam's been altered on two fronts, sort of requirements for the exam, but also some of the substance of what brokers and real estate agents will be learning through the exam is changing. We'll start with some of the requirements. So previously, a non-licensed real estate experience could be used to qualify with the exam. I don't think there was a time limit on it. Now, any non-licensed real estate experience that a broker is bringing to the table as a part of applying for their license has to be within 5 years of them taking the exam. So there's a 5-year cap on any previous experience you've had as a real estate broker to take the real estate broker's exam. When we're talking about the actual exam itself, for anybody that's going to be applying to the real estate broker's exam or to the real estate salesperson exam, these changes are going to be on both. First, there's going to be explicit training on implicit bias. And so this will be both, I believe, on the written portion of the exam, as well as a practical acting out different scenarios. So it's going role playing. I think that's the word I'm looking for. There's going to be parts of the training and parts of the exam that test implicit bias, and there's going to be new training that revolves around federal and state level fair housing laws. And I believe that also involves both on the actual written / multiple choice portions of the exam, if that's even a real part of that exam, but also role playing in that scenario as well. And the one other change, which is interesting, it's not really connected to the exams at all. They've extended the deadline. When you pass the real estate sales exam, you have to publicize notice in a newspaper within 30 days that you're a real estate agent. If you're going to be practicing in that market, you now have 45 days. So you have an extra 2 weeks to get that done.
Nice.
Yeah, giving you some more time to do that.
All right. So it looks like they're going to have to study more, and they're given some more extra time.
Yep.
Great.
Yep, absolutely.